Thank you, Shalini. Good evening, everyone. I have been told to introduce someone who actually needs an introduction in this forum. So instead, I will celebrate her by telling you some things about her, which actually make her such an amazing and learned person we all have come to know. Ms. Meenalall. Madam Meenalall is a gold medalist in LLB from Jabalpur University. She started her career as a court practicing advocate before the High Court of Madhya Pradesh in its principal bench at Jabalpur. Later on, she joined Tata Steel Limited as their in-house counsel. During her tenure at Tata Steel, Ms. Meenalall rose through the levels and has been heading the legal function of Tata Steel since 2008, in her current designation as Chief Legal Officer, Industrial and Litigation. Ms. Meenalall has dealt with litigation in diverse fields of law, such as criminal, land, mining, environment, forest, labor, to name a few. She has the experience in the field of contracts of several kinds and, of course, dispute resolution. She's a keen learner and a very passionate professional. She has contributed to volume 8 of a book series written by Mr. Samaraditya Pal titled Constitution of India, Its Origins and Evolution. Continuing her learning streak during the academic year 2019-20, she enrolled for the post-graduation diploma in cyber law and cyber forensics, which she has completed recently. Also, to her credit, recently she has been recognized by BW Legal as one of the top 100 general counsels of India. Ladies and gentlemen, Ms. Meenalall, ma'am, over to you.
Thank you, Tripti. I accept all what you said with modesty, and as you said, I continue to be a learner before this August forum also. And let me state this with humility that I am on a daily basis, the interactions that we have in this group, I'm really learning and looking forward to more and more of that. First of all, friends, let me say this, a very warm good evening and welcome to all of you to this Gyanavardhini session. I bring to you a very different, a very narrow, a very in-depth and a nuanced perspective of the laws related to information technology and, of course, eventually data privacy. We have dealt with various aspects and so many of you have given enriching presentations. I thought it would be worth a while and it might add a little bit of value to all what we already know. And this is a pool of professionals who is keen on learning. Therefore, I thought this subject also could interest all of you. To begin with, to quote Gandhiji, as he says, you must be the change you want to see in the world. And that is what FDPPI is about. This group having the ambition of being the thought leader in the field, in the regime of information technology and related laws and applications and all its entire spectrum of information technology, this topic would become increasingly relevant is what I feel. And I promise you, my effort is to bring on the table some suggestions at the end of the presentation. Having said this, I must also state that I'm deeply thankful to Shalini, who not only has coordinated the session, but also has willingly agreed to help me with making the presentation since I'm doing it on iPad. And I found it a little difficult to share my screens and move the PPT up on the iPad. So with this brief preface, Shalini, let's move on. And let me first introduce the topic to all of you. Let's talk about it. Shalini, let's go to the next slide. Yeah. So the topic, the way the topic was, and Shalini and I spoke quite a bit, and I believe that Mr. Navi was immediately able to associate with what I'm talking about because he has been reading up so many things on law. So he was immediately able to associate. But some people would still wish to understand a little bit of detail of the topic. What does this really mean and what is it that we're going to talk about? So we all know the intermediaries around, the Googles, Twitters, Facebook, WhatsApps. We all know the intermediaries. But there is a concept which applies to intermediaries, which is called injunctions. What is injunctions? We will dive a little deeper in this session. What is injunctions and how is it relevant to intermediaries? But the picture that I've put up in the section of injunction says it's a pretty good injunction, but I wouldn't say that it was a super injunction. So how do we make an injunction super when it comes to intermediaries is the theme of this session, if I may put it. Then deriving out of that, we shall discuss the implementation effectiveness of any injunction that is granted by a court. The injunctions are always granted by the courts. Shall we next? Now, what is the agenda of the session? I've divided the agenda of the session into 3 parts. One is digital world and the concept of injunction. Let's apply the concept of injunction to the digital world. There are certain case laws which are available globally as well as domestically. Number 3 is suggestions, and I would be extremely happy if we had some discussion around the topic. Next. So the first set agenda that I'm going to take up is the digital world and the concept of injunction. What are we really talking about? Yeah. Shall we next? Yeah. Why I was inspired to do this session? Actually, the inspiration came to me when I read the judgment of 20th April of Delhi High Court. It's a very detailed judgment. It refers to many earlier case laws, so which means it makes it more detailed. The parties are X versus Union of India. The judgment was given by a single bench, Honorable Justice A.R. Bhambani. So that's what inspired me to dig a little deeper into the concept and figure out what it is. And I thought I can share with this group. Yeah. Now, what are the facts in this case? If we may look at the facts are very brief. The petitioner went to the court, and the petitioner has been anonymized, went to the court and made a complaint. The petitioner said that photographs and images posted by the petitioner on her private social media accounts, Facebook and Instagram, were taken away without her knowledge or consent. And the images have been posted on a pornographic website, that is www so and so, by an entity called Desi Collector. What is important is the social media accounts of petitioner had requisite privacy settings also, which were activated. There have been captions added to the photographs. All this is her complaint. And the photographs have already received so and so views within a week of posting. So see the swiftness with which a person has to act in going to the court or to the regulatory or to the statutory authorities. Yeah, next, Charlie. Now, what are the allegations being made and what are the challenges that the courts are facing? Allegation is, of course, violation of Section 67, which is 67 of Information Technology Act, which actually deals with punishment for transmitting obscene material in electronic form, and the punishment is 3 years, or on a subsequent offense it is 5 years, and some fines also. Petitioner had already moved a complaint before National Cybercrime Reporting Portal and to the jurisdictional police. So jurisdictional police means the FIR, wherever the FIR is filed and wherever she has come across the offense having been committed, and to the jurisdictional police thereby, and no action is being taken. The offending content had been redirected. In fact, there was a further violation by redirection of the offending content and republished on other websites and online platforms. This is the complaint. These are the allegations she makes. Now, there are certain challenges. And what are the challenges? The CYPAD, that is the Cyber Prevention Awareness and Detection Authority, it came and said, because the court called it came and said, while it was ready and willing to comply with the court directions of removing or disabling access to the offending content, but by reason of technological limitations, it is being prevented to do so. What prevented it, or what was its point? We'll soon come to that. It is pertinent that SciPad could not assure the court that the offending content cannot be effaced or can be, sorry, effaced from the World Wide Web. There was no assurance which could be given to the court, and that is where really the problem rests, and that is where the nuance comes in. Technologically, they say it is impossible to entirely efface offending content from the World Wide Web. This is the challenge that the authorities have come back and presented. Yeah. If we can move on. Shall we, are we going to the next slide? Yeah. What is the question that the court is asking itself? The court is asking a question, and which we in legal terms call issues. And these are issues are nothing but actually questions that the court is framing for itself to answer. Court framed questions, and these are very pertinent to understand. It says where a party has sought any relief from the court to the effect that certain offending and illegal content be removed from World Wide Web. The court is asking what directions are required to be passed to make its order implementable and effective, and which parties such directions are required to be issued to. Normally, you see what happens, A files a case against B, or likewise. So there is a named plaintiff and there is a named defendant. But in this case, the court is asking which parties would comply with the directions that the court passes. Then the next question that the court is asking itself is, what steps are required to be taken by law enforcement agencies? So the court is saying, okay, we take upon ourselves the task of passing the directions and delineating the parties which are required to comply with such directions. What are the actions that the enforcement agencies should take to ensure that despite court orders, the offending content does not resurface or remain available on the World Wide Web at the instance of errant parties, and such parties do not succeed in brazenly evading compliance of such orders or directions with impunity? Now, there have been instances of evasion of compliance, which I will share with you. So therefore, in nutshell, the court is asking itself a question: what would the implementable and effective directions be? So friends, let me tell you here, why is the court worried so much about effective directions? We have seen that there are pages after pages written to pass a judgment. The courts pass the judgment. Now, how well that judgment has rendered justice is a very important aspect. And in matters like these, it is extremely important for the courts also to appreciate the fact that its directions should be A, implementable, and B, effective enough. So that's the question the court is worried about. Yeah. Before we go further, it's really important to spend a few minutes on what is injunction, its concepts and contours. What is injunction? Injunction is not a statutory remedy. Its procedures are provided in the statute, yet it is not a statutory remedy. It emanates from a combination of equity and morality. Somewhere the statutes will capture it. For example, in India, the Civil Procedure Code prescribes how injunctions are to be sought and granted. Specific Relief Act also, the statute in India also talks about certain injunctions. But by and large, injunction is a discretionary process for preventive and remedial justice. And what does it do? It directs refrain from doing a specified meditated wrong, not amounting to a crime. If it is criminal, then obviously there are processes under the IPC available. But if it is IPC and CRPC, but if it is non-criminal, which is a civil wrong, it is a meditated wrong, then obviously one can approach the courts for grant of injunction. Now, the injunction is known worldwide by different names. Some of these names which I've captured over here, it's called a John Doe order. And there is a very interesting history which goes back to John Doe. It actually, the term was coined in medieval England during the time of King Edward III. And, you know, in India, this has been conceptualized really in a judgment of 2002, again of Delhi High Court, where this was a case actually filed by Taj Television Limited against one Rajan Mandal. They sought the relief to restrain unlicensed parties from broadcasting FIFA, the World Cup FIFA of 2002. There, Delhi High Court gave it the name, these orders will be called Ashok Kumar. So that's why the last point that I've written on this box is Ashok Kumar. These orders in India are called Ashok Kumar orders. But in Israel, they can be called Israeli. Rolling Anton pillar orders is another name which is given to these kind of orders in Canada. The kinds of these orders which can be passed by the courts are, they could be temporary, they can be perpetual, and they can be mandatory as well. It could be a combination to say that this is a perpetual mandatory injunction or a temporary mandatory injunction. Normally, mandatory injunctions are granted at the end of the litigation, that is, in the final verdict of the litigation. Also, let me tell you this rolling Anton pillar orders also is a terminology coined in Canada when there were certain issues raised amongst the directors of the company. So that's how this rolling Anton pillar orders came about. Yeah. Can we go to the next slide, please? Yeah. Before granting an injunction, the courts are required to look at 3 cardinal tests. The cardinal tests are, and there is this filtration which is extremely important before granting an injunction. After all, the court has 2 parties, and the court is really restraining a party or the other side or the defendant from taking certain action. Now, the 3 cardinal tests are, there is a strong case for trial. That is, there is a strong grievance which has been committed to the plaintiff. The party who goes to the court is called the plaintiff, to the plaintiff, which requires evaluation from the court. Therefore, there is a strong case for trial, which should be much more than a prima facie case. Okay. And it is required, the court therefore would sit down to understand if prohibitory orders should be passed at the threshold. When we talk of injunction, friends, let me tell you, these are orders which are passed at the threshold also. So the party goes to the court in the first hearing, an ex parte order can be passed. Ex parte order, when I say, I mean without hearing the other side. The plaintiff could get an injunction order. So therefore, these cardinal tests are very, very relevant. So test one, that there is a strong case for trial. Test 2, this order is very necessary to prevent irreparable or serious injury, which cannot be compensated in terms of money. For example, defamation cannot be compensated in terms of money. Copyright violation, no. Similarly, on the digital medium, if there is some offense happening, it cannot be compensated. Anybody's credibility in the society cannot be compensated in terms of money. So therefore, it becomes an important consideration for the court. Then the balance of convenience is in favor of the one seeking such relief. So there is always a balance that the court has to draw, and the convenience balance should rest in favor of the party who's asking the relief. Yeah, Shalini? With this, let me come to certain case laws. How are these injunctions applied? Because, we spoke about what is injunction. We understood a little bit about its kinds, how they can be granted, its tests. But let's look at some of the case laws which are very, very relevant. And these case laws will also show how parties can continue to define the injunction orders, some of these case laws. Yeah. There is a case of Australia, 2017 Supreme Court case of Australia. I'm sorry, friends, lawyers are known to be verbose. However much I try to make the presentation less verbose, I hope the attempt is successful to some extent, but I'm sorry for the verbosity, although I will not take you, not think that you should, stress yourself in going through each and every line. That's not the purpose.
It is very helpful. And the way you are clarifying, it is helpful that you put it in this detail. Thank you so much.
Okay, thank you for that. So there were 2 defendants in this case. Now you see, as I told you, in the case X versus Union of India, the court scratched its head as to who are the parties against whom I should pass the order. Why that question came up, it will become clear with these illustrations. There were 2 defendants. One was Twitter Inc., which is Delaware Corporation in California. This is responsible only for the operations in the US. There is another Twitter International company, which is an Irish corporation, Dublin. Worldwide operations outside US is in control of Twitter International company. So that's the territorial distinction between the 2 of them. What is important is the Australian Twitter entity, that is Twitter Australia Holdings Private Limited, it was not a party. Although the case was filed in Australia and there was a grievance to a person in Australia, but Twitter Australia was not made a party. Yet Twitter Australia is a wholly owned subsidiary of the Irish corporation. Now, what is the privacy policy that Twitter has? And all of these companies will, mind you, talk about their privacy policy. It said that explicitly that if the user lives outside US, the data controller responsible for your information is the Irish corporation. So that's how this Irish corporation was made a defendant. Defendants did not participate in the proceedings. Now, let me tell you, Irish corporation did not participate in the court proceedings. Twitter Inc. did not participate. There were only email exchanges which were happening at the support, very, very much liked, they think very much like user-friendly support button that they have. The issue which arose over here in this case is jurisdiction to grant injunctive relief against foreign defendants in absentia. So you see, the order had to be passed against Twitter Australia Holdings Private Limited, which was not a party. So could the court pass an order in absentia was a question that the court framed for itself. Yeah. Shani, let's move on. Now, there are facts in this case. How are the facts connected to what the court did? There were offending tweets which appeared between 16th and 19th May 2017. The author used a Twitter handle that falsely adopted the name of the plaintiff's CEO. Here again, you would see that the plaintiff is a company, yet its name has been kept anonymized by the court. Plaintiff wrote to Twitter Inc. that there has been an impersonation of CEO of the plaintiff and made a request to remove the offending material from the website, deactivate the fake user's account, prevent the user from publishing further confidential information on Twitter, and also to provide the identity and contact information of the user. These were the requests which were made by the plaintiff. The response of Twitter was it had removed reported account for violation of Twitter rules. So you see, it says, I have my rules and I have, these are impersonation policy. There are some other rules that Twitter has. And they said for violation of my rules, I have really deleted all of this. User information was yet not released. And they said, as per privacy policy, Twitter does not release user information except as required by valid legal process. And offending tweets continued. Because the user information was not released, whatever was there on the website was taken away, yet the offending tweets continued. When the matter went to the court, the Supreme Court granted the injunction and it told Twitter Inc., the Irish corporation, that please remove everything which is related to these kind of tweets. That's how the injunction came in handy to this company. Yeah. The next case is actually more interesting than the Twitter case. And this is how you see the corporate house, the manufacturing companies or service companies could suffer at the hands of the digital platform. This is a famous case of Google Inc. versus Acoustic Solutions, which is again 2017 and Supreme Court of Canada. What are the grounds that... Sorry.
I am sorry to interrupt. Before you go ahead with this case, we have a question from Ms. Bengeri, which I thought should be. So she's asked.
Okay. Does it mean that it is an advisory action? Reena is asking, does it mean that it is an advisory action given by the court or injunction? No, it's not an advisory action. There is a whole lot of literature and whole lot of judicial precedent to injunction. And it is somewhere related to equity, which means the law of tort, basically related to the law of tort, which has not been codified in the manner as a statute is codified, as you would hear Information Technology Act. So there is no act which will talk about this injunction and that. But in India, as I said, there are some statutes. Largely, it emanates from equity and the law of tort.
Okay.
Okay.
One more, I mean, just because you're discussing this case, I was looking at when you're saying offending tweets to be removed by Twitter, right? So the the offending tweets considered by Twitter may not be the same which I am considering as offended, right? Offending. So how do you meet in the common ground actually?
See, in the common ground, the plaintiff has to be extremely crisp and crystallized to say that I am so and so. This is a post which is published, which is, in this case, let's say in the case of Twitter, it says this is impersonation of the CEO. So in the name of the CEO, certain tweets were being made. Okay. And either in the name of the CEO, they have not described the fact to that detail. They said in the name of the CEO or in the initials or the syllables of CEO, these tweets were appearing. Either in the name of the CEO or certain tweets which were giving the information of the company, but were not being released by the CEO. So that's how this impersonation was also coming about.
Okay.
Yeah. Talking about Google Inc. versus Equistech, because I work for a business house, so therefore I'm keen for people to understand how the business gets impacted. Now, Equistech, if we may call it E for the purpose of this discussion, it's been a technology company and had a distributor called D, that is Datalink. We are very familiar with Datalink. The distributor began, what did E start to do? It began to relabel one of the products and pass it off as its own trademark violation. It acquired confidential information and the trade secrets of E, used them to design and manufacture a competing product. As a result of that, what happened is the business of Equistech, if the left arrow is visible to you, it's in the red, shows that Equistech business deteriorated substantially and consistently. At the same time, the business of Datalink, that is D, it continued to rise incessantly. What did Equistech do? It terminated the distribution agreement that D had and demanded that D delete all references to Equistech's products and trademarks on its website. The suit was filed in Canada. D had so now look at the smartness of D. D had a myriad of shell corporations in different jurisdictions. 2012, Mareva injunction was granted. Mareva injunction is also a variety of injunction which says, here, I'm seizing all your websites. I'm seizing all your equipment. I'm seizing all your... So freezing of website is called, or freezing of accounts is called Mareva injunction, which is very, very popular in the world of arbitration. So Mareva injunction was granted, which injunction was not complied by D despite arrest warrants. So mind you, D had the impunity to not comply with the court judgments despite arrest warrants. Not knowing where D or its suppliers were, he approached Google and requested for de-indexing the websites. Now, Google asked E to obtain a court order, as any of these parties would do. The injunction was granted, not only granted, it was granted by the court below and affirmed in appeal. Okay, that's what my little verdict on the right-hand side shows. Yeah, Shalini. So, what happens further in this case? There are 3 rounds of litigation. G complied with the order by removing specific web pages, and pursuant to its internal policy, it only de-indexed individual web pages, not entire websites. So look at how G is complying, Google is complying with the order. E discovered that de-indexing web pages, but not entire websites, was ineffective, since D would move the objectionable content to new pages within its websites. What is important is Google had limited de-indexing to searches that were carried out only in Canadian Internet Protocol. Right? That is the one it applied, and it de-indexed only for Canada. Yet again, D went to the court and said, please give me an injunction on Google from displaying any part of D websites, Datalink websites, on any of its search results worldwide. Google approached, now, while this was going on, Google approached the US District Court, that is California, and sought a declaration that Canadian court order was not enforceable in the US. So very proactively, Google goes to US court and says, this doesn't apply to me. Canada doesn't apply to me. Territorially, that is Canada, I've complied. In US it doesn't apply to me. Yet again, there was another litigation, that is Equistech 3. lastly, the Supreme Court of British Columbia rejected the request of Google. And it said that, no, you have to take care of this. You have to apply this order globally across boundaries. The relevant facts which were placed before Equistec are Google controls so much of global searches on the internet. And this ability to sell largely is contingent on the customers being able to locate its websites through G's search engine. Because G keeps indexing and facilitates searching, therefore it's always possible for any customer to get attracted to D because data lake would price it cheaper than Equistec, and therefore Equistec consistently lost business. And this is how finally it got the relief.
So Meena, how was Canadian court order not enforceable in US? What was the, I mean, supporting thing?
So very interestingly, Reena, what they said is there is a freedom of speech which is very, very expressly contained in a US law. Now, if I were to de-index certain things which my customers in the US are wanting me to index and present them as information, that would actually amount to lack of freedom of expression. And if I did that, I would lose certain benefits as I have being a resident or this corporate entity residing in the US. So, these arguments are all getting mixed up. The freedom of speech and expression in India, you will find Puttaswamy being discussed, Shreya Singhal being discussed when WhatsApp issues are going on. So all this is getting mixed up. So that's how these mixed up arguments were presented. And Google could get away by not enforcing its order across. It says, I will apply this only in Canada. So that's where these, they would show policies, etc., etc. So now, when the registrar says, I don't want to participate in the proceedings, similarly, these companies also come and say, I will share this with you in India context also. They will come and say, we will abide by the court orders. And this is how then they will interpret and abide by the court orders. This is their own interpretation. This has nothing to do with courts not being informed. Courts are very well informed that this is what is happening with over the internet medium.
No, because you're saying indexing of those websites and all, possibly they should have known that this is also an option of only indexing the required websites or whatever, right? So that that particular order should not have got passed, right? I mean,
no, they passed the order saying that this is the characteristic of a John Doe order in when it is applied to a website. What I want to distinguish here is there is a John Doe order which is passed by the courts, why do we call it a John Doe order? John Doe order is an order passed against unknown people. So this is also a kind in that format. This has the characteristic of a John Doe order, and it has to be understood because they sought a John Doe order and they got the Anton pillar, let's say for Canada. They got that order. Therefore, Google had to apply it across territories. There was no way that Google could interpret to apply it only to Canada. Now, the context was a John Doe order.
okay. Thank you.
Yeah, Shalini, let's move on. So there is this another case, in the garb of certain interpretations, again, this case comes up, which is, I don't know, it went to ECJ for the purpose of interpretation of a EU directive. EVA is a member of National Council Austria, and there's a case which is coming from Australia and relates to Facebook Ireland. It operates global. Facebook Ireland, we know it operates social media for users outside US, Canada, and in Ireland. In April 2016, a Facebook user shared on the user's personal page an article from Austrian online news magazine, which had the effect of generating a thumbnail of original site containing a summary of the article and a photo of Eva. User also published a comment on that article, which is found to be harmful to the reputation. This could be accessed by any user, obviously. Eva wrote a letter to Facebook to delete that comment. Facebook merely disabled the access in Austria to the initial content, right? That's what Arena was just now raking up. Now, the court sat down and the matter went to the court as well. Whether the cease and desist order, which the court is asking itself, whether the cease and desist order made against a host provider, which operates a social network with large number of users, may be extended to statements with identical wording and or having equivalent content of which it is not aware. So court is here making itself aware that there could be something which it is oblivious to, and therefore whether we have the jurisdiction to pass a blanket order. Yeah. Next, Shalini. So this matter also, sir, I will in a moment come to Baba Ramdev order as well. And here, in the case of Facebook, the Supreme Court directed where the host provider is already aware that the interests of the person had been harmed, such an obligation is proportionate, which means the website needs to, or Facebook needs to carry out the obligations in proportion to the damage which is occurring. But there was a directive of Directive 31 of EU, which was causing some irk in the mind of the Supreme Court, and therefore it referred the matter to ECJ. And the question really was, there was a digital commerce directive, and the question that was asked in that directive, in the context of that directive, is under Article 15, does Article 15.1 preclude any of the obligations as follows: to remove not just the original information, but also other identically worded items of global information, which is worldwide, and they've categorized worldwide in the relevant member state of the worldwide use of the relevant user worldwide, of the relevant user in the relevant member states only. So this is how they thought that we should first interpret Article 15 of EU, whether it is causing any embargo. And they said that there is no embargo being created. Article 15 does not come in the way. So therefore, it has to be deleted. The orders could be passed without any boundary, geographical boundary, or any corporate boundary. And that's how this case came to an end. Yeah, let's go on. Sorry. Shalini, your screen is not visible. Yes. Now let's come back to the case that we started with, X versus Union of India. Yeah, Shalini. What are the arguments that are being presented by all of these parties? So Google says, law has not asked intermediaries with policing, not tasked us with policing or monitoring content for due diligence. Everybody has a similar, not the same argument. So there is an argument of Google, there is an argument of Internet Society of Internet Society of India, which also advocates Internet Service Providers Association of India, which also advocates the issues of ISPs, and there is a argument of Instagram and Facebook separately. All these people, in nutshell, they are saying that we are not tasked with any policing. Google is statutorily exempt from any liability. So there they come back to Section 79 of the Information Technology Act. The role of Google is only to de-index the content, technological impossibility of monitoring unlawful content. Then intermediary includes internet service providers, they are saying. And that's how ISPI also walked up to advance the arguments. And it says ISPI members are only those entities that enable access to the internet, but do not control content hosted on websites or online platforms. ISPI members enjoy safe harbor. And we all know what safe harbor is. Facebook has a robust policy. As I said in the beginning somewhere that they will talk about policies. So Facebook has a robust policy to provide safe online experience. Users have various privacy settings by which they may restrict access to the content. Facebook has features called Profile Picture Guard and Audience Selector, with the help of which they can experience safe online usage. A little more in detail, I put up the arguments of Google on the next slide. Of course, these are the arguments presented by Delhi Police. You see the number of parties who are eventually getting involved in the case. Delhi Police says directions ought to be issued to intermediaries under 79 3B of IT Act for removal of the content from where all URL, account ID, handle name, IP address, hash value, pixel matching, structural similarity index. And law enforcement agencies are asked to adopt the method of letters derogatory issued or resort to MLATs even when the unlawful content has been hosted from an Indian IP address. So these are the constraints that they are projecting, and this is the list that they gave that we must, the orders must direct removal of content from all of these locations. Yeah. Google says it has no information on actual nature of offending content in question. So, okay, all right. It would not oppose removal of the content as directed by the court. As I mentioned, they either do not participate or the participation is very, very passive. Intermediaries running search engines called Google Search are not publishers. They merely index existing information, which is what we are talking about. Publisher website is controlled by a webmaster or owner. Google does not publish nor host or control any content. Search engines access only a small portion of the World Wide Web and private networks. Legal framework mandates that the internet be kept free from editorial intervention. The software crawler sorts the information. It only sorts the information on a web page into an index. Similar content is grouped together. Text can be made non-searchable only by the webmaster or owner of the website, or by adding a code that is robo text to the website root server, by adding meta tags such as non-index to the HTML code. So this is what very technical argument was presented by Google. And yeah, next slide, please. Now, before we come to the conclusions, let me tell you one thing. In 2019, there was a case filed by Swami Ramdev against Facebook. And similarly, an interim order was sought. The interim order was passed on 23rd of October 2019. What happened in that case really is, and Mr. Navi just now wrote in the chat also, Baba Ramdev and Patanjali Ayurved, the company itself, they went to the court against Google Inc., YouTube LLC, Google Plus, Twitter, and Ashok Kumar's, that is John Doe's, which means they said that even if I do not know and I have not named any person as a defendant, yet I want an order against that person. Now, what was the grievance really was that various defaming remarks and information and videos were floating on the websites which against Baba Ramdev, which were based on a book. And the title of the book is Godman to Tycoon, the Untold Story of Baba Ramdev. Here, Justice Pratibha Singh passed an interim order. Now, let me tell you, Justice Pratibha Singh initially gave an ex parte order. After that, views were invited from Google, YouTube, etc., etc. They all came, they appeared, and the order which is being passed on 23rd October 2019, that is also an interim order, as I said, temporary injunction order. That order has been appealed against by one of these parties. I don't know who has appealed, or all of them might have appealed. The matter is pending in appeal. All I'm saying, why I'm telling you the context of appeal is the jurisprudence around these aspects, insofar as the social media is concerned, the websites are concerned, it is yet to evolve. It is at a very, very nascent stage in India. And that's where Justice Pratibha Singh also discusses the geo-blocking. And she asks the question, what is geo-blocking and what is global injunction? Is India supposed to order only geo-blocking, or it could order a global injunction? Yet, let me tell you, friends, they have done a combined reading of certain provisions of the IT Act, and rightly so, and they have issued global injunctions. So like Justice Pratibha Singh issued global injunction in the case of Baba Ramdev, similarly, global injunction was issued in this case that we are discussing, X versus Union of India. The legal position which has been settled and which is here to stay, this is a correct legal position, correct application and interpretation of the IT Act on a combined reading of Section 1.2 and Section 1.2, Section 81 and Section 75. Section 81 deals with overriding aspects of the IT Act, but certainly Section 75 and Section 1.2 make provisions of application of the Information Technology Act, even when the parties are not located in India, but the concerned computer is, or the gadget is located in India. So that's how the global injunctions have been issued. It's not only a question of geo-blocking. Now, what are the conclusions that the court came to? Technical conclusions I just mentioned, that a combined reading of these provisions has been carried out. But how has the order been directed to be implemented? Petitioner has to furnish to the investigating officer all information, including the image URL, web URL pertaining to the offending image files. Delhi Police or SIPAD cell directed to remove or disable access to offending content, the web URL and image URL from all websites and online platforms forthwith. Within 24 hours, they were given the time of 24 hours. Search engines, Google search, Yahoo, Microsoft, Bing, DuckDuckGo, to globally de-index and dereference from such results the offending content, de-indexing and dereferencing all web pages, Google search, Yahoo search, so-and-so to endeavor to use automated tools. They have been recommended, it has been suggested, and recommendation has been given by the courts to please use automated tools to proactively identify and globally disable access to any content. Kind of a holistic order which has been passed by the court in this case. Now, let me pause here for a moment and let me take you all to a regime where these kind of orders, not exactly in this form, but a little different characteristic of those orders, which are peculiarly John Doe orders, are passed in the case of offense committed or offending act under Copyrights Act. If there is a copyrights issue and violation of a copyright, and the copyright issues have gone to the Bombay High Court in multiple Bollywood films. You talk about Singham, you talk about Happy New Year, and so many, even the art movie Waiting, every such movie has gone through a round of litigation to seek the orders under Copyright Act for preventing violation of copyright. These are peculiar cases where courts have passed John Doe orders because court does not know who will infringe the copyright. And therefore, these orders against unknown people have been passed. That is what Baba Ramdev case also did. They said, I want orders against Ashok Kumars. So Ashok Kumar is an unknown entity, but it will apply to everybody. The Copyright Act, the concept of defamation and patent protection or patent infringement, if I may say, these are specific areas where such kind of orders have already been passed. The search engines, the social media, they are now developing and coming closer to those kind of orders. So while the search engines are also being made parties to these proceedings, yet there can be something which can be left out. So that's where I want to give deal with the last chapter of the presentation. Yeah, Shalini. So we come to the last and final chapter. There are some suggestions. So I'm saying there are challenges in implementation of such orders, undoubtedly. Policies are not enough. So these companies and the corporate houses must realize that policies are not enough. Each case, and for the public also, each case requires a determination from the court, because as we saw, Google told Ecostech, please go to the court and obtain the orders. So which means that somebody has to determine that what is happening is illegal. And therefore, determination from the courts is very, very important. Each case requires a determination from court about its illegality. Compliance of court orders is a matter of concern. As we saw, the court is asking a question to itself. Absence of mechanism to verify the website's block. This is a large gap. This is a gap which is existing. Thin difference, as I said in one of the conversations a short while ago, thin difference between allowing freedom to express and the intermediary obligations, that's quite thin, and travesty cannot be ruled out. Indian courts have believed in global injunctions, but there is no uniformly universal laid down approach. So this is an issue where really some uniform universal approach will have to be eventually culled out by all the nations, because while the world is becoming small, but it is becoming very complex as well. Now, to deal with this situation, obviously, some uniformly universal policies will have to be applied. Yeah. Now, here are some suggestions that I'm making. There needs to be a proper mechanism for verification of the websites blocked. It is imperative to verify the names of websites provided by the plaintiff for completeness. Even though the court would pass the order against Ashok Kumar, there could still be incompleteness of enforcement of the order. Adoption of check and verification method was hugely advocated by late Professor Shamnad Bashir in copyright matters, because that was, as we said, John Doe orders, unknown people. So this was one check and verification method that he had advocated for copyright matters, which I am bringing on table, that possibly these could apply in cases against the social media platform also. What should happen is what I can think aloud, and many of you are experts to contribute to this area and we can think aloud and go forward with some suggestions. It is in the check and what is the check and verification method? The method is neutral verification agency come ombudsman method. The list of suspected websites or URLs provided by the plaintiff may be verified by a third party, a neutral party, let's say FDPPI. The CBN would finally approve the list of websites and provide to the regulatory authorities directed by the courts to enforce the orders of the courts. The courts may also direct receipt of a report from such ombudsman certifying compliance. The reports could also be sought for at some interval so that there is no recurrence of or there is no defiance of the court orders after an interval, or at least till disposal of the case. You see, how should all this be done? I thought about it as to how should this be incorporated into our system. For the purpose of incorporation into our system, probably one advocacy which is required is these kind of procedures could be incorporated in the rules of the High Court to say that whenever a plaint is filed by a plaintiff which is against, which is asking for Ashok Kumar orders, what is the necessary prerequisite? Please get us a neutral a report from an ombudsman, which will be a third party, and each High Court can have a list of ombudsmen that it can have in its own list as they have arbitrators. Similarly, from the list, people can pick up the ombudsman and people can get a neutral report. And along with that report, when people go to the court, the orders which will be passed by the court, they will be far more crystallized, far more focused, far more suggestive, and far more easy to enforce. And over and above everything, there will be far more completeness in rendition of justice. I must also say this, that with the increasing use of internet, one can expect that these kind of issues are going to land up in higher numbers before the courts. There will not be enough time with the courts. We know how the systems are. It will take time for the courts to deal with the subject. Therefore, getting a neutral person's report will also enable the court in quickly passing the orders of injunction. This is a suggestion that I have. Obviously, we can, as we go forward, we can design it and make it far more crisper. And if it works, it can be to the advantage of this group as well. Shall we next? So I think with this, I come to the end of the presentation that I have prepared. There can be a lot of questions: who, what, where, when, why. There can be question answers. And thank you very much for hearing me out so patiently. And I'll be extremely happy to receive your feedback or questions and happy to answer them to the best of my ability. Shalini, we can stop sharing the screen so that we can. Yeah.
Any questions? Navi sir, would you like to add to the discussion? Okay, there is a question.
Let us see what others have got as questions, because we are discussing this Twitter issue even now, right from and also WhatsApp. So I think whatever she discussed, I think has got a lot of relevance at this current point of time. Yeah, let us see if others have got any questions. I don't have any specific questions. She has actually explained everything so clearly that I don't have anything very specific. So let us see about others.
Ji, this is Ruchika here. Good
Yeah.
to touch base with you after a long time. If you recall, we were together in the cyber law course. Your suggestion of having an ombudsman kind of association for a neutral report makes a lot of sense. It also brings to my mind the recent matter between White Hat and Rajesh Punya, where White Hat had a lot of allegations with against this individual who had written something on social media criticizing their advertising policies and how they are trying to brainwash children, very young children, to enroll into a coding course. And White Hat stated that this is defamation and they have there's some crime has been committed, whereas the stance taken by the individual was, I'm criticizing their policy, which is within my right, fundamental right to do. So that in the case of an ombudsman, this could have been handled very easily and without much wastage of time and precious time of the court. So that's a very good suggestion, and I fully support you with it. Let me know if you need any help on
Who
that.
is going to bear the cost of the ombudsman? That's the bigger question now.
Sir, the plaintiff has to bear
Why
the cost.
public money should be spent
No.
on this?
Sir. No, sir. The plaintiff must bear the cost of the ombudsman.
Who?
It is a plaintiff. The plaintiff who goes to the court should bear the cost of it. Is something like, if I am relying on electronic evidence, I must take the cost of a section 65B certificate. Similarly, here.
It is not equitable. According to me, what all these plans are all not proper at all.
Okay.
Sorry if I am hurting you.
No, it's okay.
It is just like this. Very simple analogy, we will take it. Whenever some crime happens, we investigate. People who give protection or residence, even for rent, you are going to take action on the person who gave them for rent. Okay, whether he is in the knowledge of it or not. You can look into any crime cases, tax cases, or any cases. We go to the person who provides the facility, knowingly or unknowingly, we have a power to do it. This is the companies where they are providing all these facilities to the public, to their benefit and the public's benefit. If they allow somebody to play with their facility, they are responsible. They are like residences. Why do you use the name of intermediary? We'll tell them they are the people who are residing these criminals. They are the houses for criminals, protection for criminals. Why should you provide for it? If you want to run business in my country, the first thing is whoever enters. You have seen banks having KYC norms. You are having all organizations having KYC. Similarly, we should tell them you should have KYN. Know your netizen, then only you should allow. Otherwise, don't allow. And if I do not allow any netizen, you should not transact that. That kind of law should come. It is not the public money to be wasted on this, squandered on this. Who wants this kind of facilities where it is not safe? Instead, we can throw them and we can have our own territorial limitations and our own websites and our own this one. Why should we depend on them? Even though we don't progress. So there, I do not agree. The guys who make billions and billions of rupees, earns crores of rupees, you want public money who is toiling day and out, paying taxes, that money to be utilized? Or the petitioner who is a victim, his money to be suffered? It's totally unequitable structure, which you have suggested, according to me. It should be from the party. Party is responsible for KYC norms. Similar to it, you call whatever you want. If you want anytime your website to be used somebody, you should know who he is. You should take all precautions. If you without precautions, if you allow somebody to play in your house or use your house or rent your house or use freely your house, you are responsible equally for the crime. That should be the equitable distribution according to the charts. So there, whether he abets knowingly or unknowingly, even a omission, we should fix them. The law should move. According to me, the law is not moving in direction where it is required. Changes are happening without the knowledge, this law being changed. And that is the havoc it has created. That's my opinion. Sorry if I have hurt you.
No, it's perfectly okay, sir. I bring in the perspective from the point of view of what is currently happening. What you are talking about is a macro perspective. I respect that. I mean, these are perspectives and these need to be debated, and sometimes they will get debated. So I bring the perspective on the basis of what is already existing and the way the courts are moving and the matters are moving. From a very
Okay, Meena,
Yes, yes, sir.
when
Yes,
a
sir.
court appoints an amicus curiae, who bears the cost, it goes from the court fees only, no?
Yes.
If at all there is a
Yes,
charge.
yes.
I don't know
Yes.
amicus curiae, how much they charge or something like that, but
Sir, it's different. I'll tell you, it's different for Supreme Court, it's different for High Court, it's different. And for different kinds of cases, it is different. But normally it is on a per hearing or per appearance basis.
Okay, okay.
Yeah.
See, one more interesting development recently is that in the latest case where Google has represented itself in, I suppose, Delhi High Court, they have tried to say that they are not intermediaries. Okay. And that is, they are not intermediaries as per section 79. That is what they have raised. Okay. Now, perhaps they think that it will be better if they are not section 79 intermediaries because of the digital media regulations which came recently. But if they say that they are not intermediaries, we are happy because they are saying that they don't want section 79 protection, and whatever violations of law takes place with the use of the Google platform, they are saying that I am going to be responsible for that. So I don't know, somebody has not given them the proper advice, but claiming they are not intermediaries is not a great idea according to me. Yeah.
Absolutely. Yeah, that's right, sir. But you raise a question on the group also about Twitter, whether we can get a copy of the case. I'm still trying for it, and it would be interesting to figure out what is the argument that Twitter is raising. And I'm not quite aware of Google case as well, although I want to keep track of all this.
Twitter does not satisfy the definition of intermediary in section 79 because they are like any other publication which decides to publish or not publish. So there is a decision taken about the content.
Right.
Okay. So they obviously should not have any, protection under section 79. But of course, section 79 is not a penal section directly. It doesn't say that just because you don't have that, you will go to jail for 1 year or something like that. If there is an underlying case in which the defense is presented by Twitter that they are intermediaries, therefore they should not be held responsible, that will not be entertained under section 79 safe harbor. But they may have other defenses that they were not involved or whatever is that. Okay.
Yes, sir. Yes, sir.
So section 79 is a very peculiar section because it only says that safe harbor protection will be there or will not be there. That's all.
Yeah.
Beyond that, the cause of action has to arise from some other case.
Yes. Yes. So also let me tell you, the courts are also not very, very equipped about how the technology operates. So, when Swami Ramdev case was being argued in the courts, each time the court had directed that there should be a technical person present in the court to be able to help the court understand what terminologies mean. So there is a bit of a handicap, and there is that gap which needs to be bridged as well before one can expect that, complete justice will be done. And that's another point that I want to make, Navi sir, because you keep talking at so many fora and you keep advocating so many things. When we talk about cyber issues, the larger spectrum of cyber issues, there have to be, like Cyber Appellate Tribunal, now it is TDSAT, we know. Likewise, the tribunals, as we have the tribunals for the reason of very specific understanding of the subject. Similarly, in the High Courts and Supreme Court, there should be designated courts. Only then the understanding will be perfect, far better, in depth, and then the justice will be rendered in a more effective manner, I want to say.
Yeah, that's correct. But I think the discretion is available to the judge. If he wants, he can call an expert for his advice.
Yeah. Correct.
Yeah. What you are saying is whether a panel can be created by the court, perhaps.
Yes. Yeah. So I'm recommending, sir, what I'm suggesting is High Court, for example, has a list of arbitrators which High Court will preserve. So let's say my name gets added as an enlisted arbitrator, and there is a dispute where the parties are not agreeable to who the arbitrator should be. Then the party who has invoked arbitration will go to the High Court, and High Court will then be compelled to appoint an arbitrator. So then High Court can appoint me. It can say you are appointed as the arbitrator. So there is a classification. There is a list already available. Similarly, I'm saying somebody
you may not be able to call him the arbitrator, perhaps a mediator who does the compounding kind of a thing.
No, sir. A proper arbitrator who will do an arbitration under Arbitration and Conciliation Act.
Now, if there is a provision in the Act of adjudication and then followed by appellate tribunal, which is a statutory requirement within the Act, any arbitration will have to be perhaps on a non-binding nature. Okay. There cannot be a binding arbitration when the statutory provision is that you should go to the adjudicator, appeal from adjudicator has to go to TD-SAT, appeal from TD-SAT has to go to Supreme Court, High Court. That judicial process has been set in the law itself. So therefore, I feel that if any arbitration is there, the arbitration has to be of non-binding nature. It's only a question of assisting the court with, as you said, an expert panel which might have made an assessment. Yeah. But I feel it is difficult to make it a normal binding arbitration as per the Arbitration Act.
No, sir, maybe I did not explain well. What I'm trying to say is that as every High Court has a list of arbitrators, I'm saying in this field also, when people go to the court can have certain organizations enlisted. That, you know, as a neutral party ombudsman, these are the organizations which we have listed, and parties, you please bring us a neutral party report from any of the enlisted parties, and give us a report that these are the websites and URLs over which this offending content.
You are talking of civil cases where under the Civil Procedure Code, you have this arbitration system.
Yes.
What about criminal cases?
So in criminal cases, there is no question of arbitration.
Yeah.
It has to be only the FIR and the police has to come into
compounding can still be there in certain cases.
In criminal law? Yes, it can be. But it is only the very specific offenses which have been allowed to be compounded.
Yeah. Yeah.
Not in all cases.
So what you are suggesting as arbitration will apply to the civil disputes?
Yes. Arbitration will apply to civil disputes.
Okay, but of course, today's arbitrators associated with the courts are not cyber law experts.
That's what. That's another problem.
Yeah. In fact, in the Criminal Procedure Code, T.K. Vishwanathan Committee, which made one small this thing, they suggested that at each district level in a state, there should be a committee, and that committee should have an expert from, of course, the SP will be one of the parties, but there will be mobile technology expert, cyber law expert, like that. One suggestion was made by T.K. Vishwanathan, but that report was not published. It only came out as a leaked information, but somehow it was suppressed. But he had made a suggestion that every state should have one DGP level person, that is apex person only for cyber crimes in the police. And at the district level, have a consultation committee involving public members. But I don't know whether Criminal Procedure Code has some issues there to allow public to be consulted into a criminal process. But I think as a guidance, I am sure the police inspector can consult any expert if he wants. So under that provision, he had suggested, but somehow it was not implemented. But that would have been a like what you are saying, ombudsman kind of a thing at the level of the criminal proceedings at the police level before it comes to the court.
So therefore, sir, I'm saying if there is a rule, law will specifically not provide this. Law will at the highest talk about arbitrations, or it will talk about civil procedure, pre-litigation proceedings. But as rules of the courts, if the courts start implementing these small things as their rules, then the cyber expertise will start setting in.
Yeah.
Otherwise, there is a large distance between us, between common public and people who are supposed to give justice.
There is one more interesting thing in which I am personally involved. It has not yet rolled out completely. In the Suma Shankar's case, I argued the case at the adjudication and at the TD-SAT. Both places, I argued for the person under a power of attorney.
Yes.
The bank has taken it to the Madras High Court. Okay. Now, in the High Court, again, I applied for being allowed as a power of attorney holder. The court, of course, I'm sure the court has a discretion, but the court suggested that they will make use of me in some capacity, not exactly the same thing, as a person who is aware of the case and the technology to advise the court.
Yeah.
But power of attorney was not favored. So that the person has to now have a lawyer or something, but they have said there will be some role. I don't know how it will work out.
So I will tell you, sir, I will tell you. When this UIDAI came in, the body, the organization, UIDAI set in, and it was, by the erstwhile Niti Aayog, it was notified. That point of time, a matter went to the Supreme Court, challenging this entire concept. That point of time, the director of UIDAI was Mr. A.B. Pandey, Anant Bhushan Pandey. Mr. Pandey was called to the court. He went to the Supreme Court. Supreme Court did some question answer to understand. But before that, Supreme Court told him to explain to us how this entire Aadhaar system will remain secure. And he made a presentation.
Correct.
In the same way, if Madras High Court calls you, you can make a presentation to them, explain to them that this is how the technology will intersect.
Is that different from the amicus curiae?
Yes, it is different from amicus curiae, because the amicus curiae is who is appointed as an amicus curiae is an officer of the court, and only lawyers are officers of the court. And that's how amicus curiae will be somebody who will be picked up from the bar.
So this will be like a consultant to the court, perhaps?
Yes, absolutely. Absolutely, yes.
And in the Rafael case also, Supreme Court asked the engineers to come and explain to the court about the Rafael technology.
Yes, sir. Yes.
So it's good. If the judge is really interested in bringing out a proper judgment, he will do all this.
Yes, absolutely.
Okay. Yeah.
No, ma'am, Mr. Nagendra had one question.
Yes.
About what is the role of BCC?
What is the role of BCC as in?
Mr. Nagendra, could you please explain your question?
Broadcasting content compliance, there is a forum, right? I mean, in the previous case, what we are discussing, how are they involved in this? Because as I know, they applies to only for television industry.
No, this is, are you asking question in the context of Taj Television?
Yeah, correct. FIFA.
Yeah. Okay. There were many unlicensed, this was a case really of piracy. And many unlicensed, these, what do we call them? Cable operators, they were broadcasting the shows. And now, you see, after the regulation in the piracy world, to control piracy, the regulation in the in this cable operators world has also come in. There are rules and there are set procedures to apply for licenses. Unless they are licensed, the question is, unless they are licensed, there cannot be a pirated broadcast of. So broadcaster, if a broadcaster is unlicensed, obviously there is a violation of the law and there is an offense to that extent. So they will be fully responsible.
So
and you see, in that case also, there were certain broadcasters who were named in the case and certain broadcasters who could not be named in the case. So therefore, the plaintiff there also asked for Ashok Kumar orders. So anybody who is a broadcaster and not having a license should also be injuncted or restrained from broadcasting the FIFA matches. It's like that.
Meena ma'am, here I have some thoughts that I wanted to say. Most of them are legal. One of them is I will pick up the scope on global injunction. Ma'am, you covered a global injunction.
Okay.
So one challenge that you rightly identified was enforcement. Of how it would be enforceable, because there have to be country-wise, treaties or agreements or uniform laws to sort of get it effective. A couple of things there, ma'am, that I would take into consideration. There is one of them is the actual data protection law involved and the transfer mechanism, the privacy policy involved, and purpose of data collection. Because I think a very big impact or mindset that most cases we discussed today were actually social media or messenger service based service providers, which were actually not commercial in nature when they started. Even today, you cannot just social media, but today they have become like business enabling platforms. Databases are being used to sort of, give it's kind of monetizable now, right? Till a few years ago, there was no monetization angle, because of which today data protection sort of applies more strictly. Apart from just the moral things that we were looking at, it shouldn't be obscene, it shouldn't be this, it shouldn't be that. One thing that social media laws that always have baffled me is the reputational damage, because we both know that Section 73 Contract Act does not recognize indirect and reputational damage in India. And most times, social media serves as a reputational angle to, any breach there would have a very high reputational impact. My second purpose is the sector. For example, certain countries allow adult industry, let's say Netherlands. Now, the same social media, which is boundary agnostic or geography agnostic, could be valid in one country but not valid in another. I think that is another analysis which would be sector to sector on how data is being used and how businesses are being enabled through social media handles. These were just some thoughts I wanted to share with you, because these will impact intermediary guidelines from a sense of control and from a sense of injunction and enforcement.
So, Tripti, very valid thoughts that you have raised. Just to respond on the first one, where you mentioned that we spoke about most of these cases were messenger platform cases, and social media laws really do not recognize, or the Indian Contract Act Section 73 that you brought out. You say, but there is another angle to it. I'll tell you something. I mean, an example comes to my mind, but for the paucity of time, I will not go into that example. See, the point is, these kind of cases, will they fall within the realm of the Contract Act, or will they fall up? There will be a shade of defamation. There will be therefore a shade of compensation, because if there is a lot of reputational harm or damage that is being caused to a person or to a business of a person, like we discussed DataLink was doing to Acustech, should there not be compensation recoverable from DataLink? Yes, the compensation, and in this sense, the defamation principles will apply. And you know that in civil cases which are filed for compensation for defamation, courts do grant compensation. But so far, we have heard of these cases only when it comes to print and publish. We've not really applied these cases to messenger platforms like this.
What I was saying is the shift of mindset of social media.
Yes, absolutely.
Social to a business, a commercial venture.
Yes, absolutely. Yeah, absolutely.
Agree with you.
Thank you, Meena ma'am, for a well elaborated
Ananthya ma'am, just want to highlight the technical point, because the social media companies, what they say to the court and to means general public is they can't manage whatever the user uploads, which is not 100% correct, even though I come from the technology industry, but it's not 100% correct. They can control what can be shared and what cannot be shared. The only thing is they don't want to do it, because say for example in Facebook, if I upload a photograph and then means there's nothing which says that do you want to share with XYZ, which can be easily done. They don't want to do it because they want to make it means as user friendly as possible, and like what Microsoft used to be when if you had used 95 or 98 2000, there was no whenever you install no permission was being asked from the user. So those things can be easily done, and they don't do it because they are means they will. It's not business alone. They have become something like a pseudo policy maker in many countries. So even in the Cambridge Analytica case, if you watch Mark Zuckerberg's defense, he was specifically asked, and it's that even if you type something and if you don't press enter in Facebook records it. So it's a quite business, and if you go through the Facebook ad, whenever you have time, just open a Facebook ad account and see how they can profile users, at what time, which country, what they do, and it's all there. And means if you go to the open source intelligence area, means easily we can figure out what a person is doing. So it's possible. And also from the ISP point of view, one case, 2 minutes if you highlight, because in Cisco, we have something called as Talos. So in Talos receives more traffic than Google, 3 times more, and they monitor all the attacks. So there was a company in, not company, an ISP in China, which used to send ransomware. So Talos caught that, like it was from the customer of that ISP who was actually sending this ransomware, posting this ransomware server. So we approached them and we asked them, can you actually please remove the server from your ISP? The Chinese company, as usual, never, they didn't respond. So finally, we went to the upstream ISPs and said, we will not advertise this ISP itself. So means the ISP route will not be advertised by other ISPs. So it's like a BGP route. So if we don't advertise, it will never come. We cannot reach them. So then immediately the very next day they removed it. So and even if government wants, means the ultimate thing, if government says that if these people don't oblige, government has every right to say to ISPs, just remove the route from your thing. And the only problem is others will not access. But technically, once government says, please remove this route from the ISPs, because even after government says yes, it will take some time to convert. So these companies will oblige. So sorry for that long discussion, but
no, perfect. I knew Mr. Kodandaram was,
Yeah, I wanted to add
was
one line.
bubbling with energy. Yes,
Yeah,
yes.
yeah. It is just like our East India Company. They
Yes, sir.
came in the time of business. They said they have no interest, but they ruled over us for 500 years. Now the social media is becoming an influencer. They are not coming for
Correct, sir.
business. They have come to conquer our commerce, everything, freedom.
Our mind.
Yes, that's where they are more dangerous than East India Company. Unless we wake up, we are going to lose our total freedom and surrender ourselves to those voices. So one should be very careful. That's my request. The boy has rightly added. I appreciate you. They are not commercial ventures. They are capable. They are keeping themselves blind in a very clever way, very wise way. So it's very difficult to wake them up unless we kick them, right? That's the way.
So, sir, as you said, the point is they are today not even willing to appoint a chief compliance officer who is a resident of India. How will they want to take this obligation upon themselves? As Anand says, they are quite aware of it. They are only doing user acquisition as of now. And tomorrow they will do a huge monetization by doing data analysis. Yes. The big data and data analytics is all about that. So we are definitely, by the fact that we have a Facebook account, we are using them, we are giving them the opportunity. A lot depends on the citizens also. So there are these perspectives as well.
Facebook owns Oculus, which is the virtual reality. So they have a plan, means nothing against Facebook, but they have a plan, as sir pointed out, Kodandaram sir, is they want to capture our mind and control, which can be easily done. Because I don't know, means I always tell my relatives, not especially ladies in my family, don't post your photographs on Facebook, to my sister, to my mother, everyone, that because it's easy for anyone to manipulate. And as you rightly suggested, ma'am, it's very difficult to remove that, because once it goes on the internet, it's impossible to remove, because people don't understand. So they'll get it eventually. Thank you, ma'am.
Thank you all. Thank you very much for an enriching conversation. Was the presentation.
John Doe order has become my favorite catch. Words.
Ashok Kumar. Ashok Kumar order. Okay. What is the lady's name in India?
Sorry, sir.
For the lady's name, what is it in India?
Sir, you know what? The literature also says John Doe was also supposed to be a male. So I don't know.
There is a corresponding this thing for John Doe. There is a lady's name.
I have not come across. Mareva is one thing that I found. It's in the Operation Boyle, as I said.
Yeah.
But I'm not sure of Ashok Kumar.
We will name it as Gangamma case. We will name it as Gangamma case.
Ms.
Okay.
Nal, we all really want to thank you for a well elaborated and enriching session. As you can see, Navi sir and Kodandram sir also, I mean, it's difficult to really make them discuss so much. So it's been really enriching for everybody. And I would like to request Ms. Reena Bengeri to say the vote of thanks for you.
Yeah, thanks, Shalini. Uh, Thanks, Meena ma'am. It was a very insightful session. A lot of case laws which were discussed, and we were able to connect to the topics on injunction. I think, at least personally for me, there's a lot to learn in this area, which I think will take a while for us. But all the legal experts on the forum today must have really got enriched with the knowledge which you have shared, and look forward to more such sessions with similar and interactive, discussions. Thank you, Meena.
Thank you, Rina. Thank you all very much, and good night.
Thank you.
Thank you.
Yeah, John Doe equivalent is Jane Doe.
Sorry, Jane Doe I read.
Okay. Thank you.
Thank you.
Good night. Yeah.
Thank you, Meena ma'am.
Right.
Thank
Good
Thank you,
night.
everyone.
We had a
Yes,
nice
sir.
evening. Thank you.
Yeah,
Thank you.
thank you all. Bye.
Thank you, everyone.